on the record. Today is December 9th. The time now is 1 past noon. This court is now open and in session under Title 28, Section 636, Subchapter Golf, under Martial Law, Rule 203, jurisdiction over the offense. For the Honorable Adelina-Arriaga, of the Pedrosa family, addressed to the Corporate United States Congress Oversight Committee. In today's court, we're going to have the honor to introduce some forensic evidence. Forensic evidence in regard to a speech. On this 9th of December of the year Lord 2020, 52 minutes past noon, in front of the Supreme Constitutional Tribunal from the Instituto Vasco de Derecho Procesal en San Sebastián, España, this Superior Court of Record is proud of the presence of the for the Honorable Professor Dr. Catedrático de Derecho Procesal de la Universidad del País Vasco, please welcome Dr. Antonio María Lorca Navarrete. Y ante el Ministerio de Asuntos Exteriores y de Cooperación de los países del Convenio de La Haya, convenio número 12 del 5 de octubre de 1961, and on the honorable presence of the University Basque Country Executive Director, please welcome for the Honorable José Manuel Lozante on this video trial. This Superior Court of Record proudly introduced the capacitator del Consejo de la Judicatura Federal de México, investigador externo adscrito del Instituto Vasco de Derecho Procesal en España, investigador externo adscrito Universidad de Medellín en Colombia, investigación externo adscrito de la Escuela de Altos Estudios Jurídicos, Centro de Capacitación e Investigación en Capacitación de Lima, Perú. These are the credentials for one Honorable Adrián Polanco, to which this Superior Court of Record now has the pleasure to introduce on a speech in regard to Derecho Procesal. Is also an investigator externo adscrito de la Universidad Privada de Antonio Guillermo Urelo de Cajamara, Perú, dictaminador nacional de la revista Universidad Nacional Autónoma de México, miembro adherente del Instituto Panamericano de Derecho Procesal y copropietario del bufete jurídico Polanco y Polanco, o por sus siglas P&P, Papa and Papa. En materia de defensa fiscal, autor de publicaciones destacadas, número 1, Aarón Barak, Proporcionalidad, los derechos fundamentales y sus restricciones. Reseña publicada por la revista de la Facultad de Derecho de México de la Universidad Autónoma de México, tomo 18, mayo-agosto, número 274, en la ciudad de Guanajuato, México. Régimen legal mexicano de las responsabilidades administrativas en ensayo, publicada por la revista de la Facultad de Derecho de México en la Universidad Nacional Autónoma de México, tomo 18, septiembre-diciembre, número 272, volumen 2, en la ciudad de Guanajuato, México. Número 3. Derecho administrativo sancionador. En la ley general, sancionador a la ley general, las responsabilidades administrativas, capítulo publicado por la Universidad de Guanajuato, por Rúa en el libro de Derecho Administrativo ante la crisis actual del Estado liberal en la ciudad de Guanajuato, México. Consideraciones. En el número 4, consideraciones epistemológicas respecto al resguardo cautelar de la prueba. Ensayo publicado por la revista electrónica Civil Procedure Review y también por el Instituto Panamericano de Derecho Procesal, capítulo Argentina en la ciudad de Azul, Argentina. El número 5, revisión crítica del constitucionalismo en el Estado mexicano, ensayo publicado por la revista Educación a distancia en la ciudad de Madrid, España. Prolegómenos del estado actual de derecho probatorio ensayado, publicado en la revista de la investigación jurídica, avances de la Facultad de Derecho, por sus siglas Charlie, Papa de la Universidad Privada Antonio Guillermo Urrelo de Guanajuato, de Cuajamara, Perú. El número 7, en el análisis de la ley de extinción de dominio del Distrito Federal desde la óptica de los derechos fundamentales, ensayo publicado por la Fundación Manuel Jiménez Abad de Estudios Parlamentarios y del Estado Autonómico, cuadernos digitales en la ciudad de Madrid, España. Number 8. Consideraciones epistémicas respecto de la decisión en materia procesal penal, ensayo publicado por la revista Academia en Derecho año número 6, número 10 del 2015, Papa 271-240, India, Sierra, November 2215-8944. Universidad Libre Seccional Cúcuta, Facultad de Derecho, Ciencias Políticas y Sociales, and Centro Seccional de Investigaciones. En el número 9, el breve análisis hermenéutico respecto de la imputación jurídica de la hipótesis normativa, fácticas en el derecho procesal, ensayo publicado, Investiging Ciencias Sociales y Humanas, volumen 6, número 1, en Pasto, Colombia. El número 10, la cosa juzgada en materia penal, ensayo publicado en la revista de investigación jurídica y avances de la Facultad de Derecho, y Charlie, Papa, de la Universidad Privada Antonio Guillermo Urrelo de Cajamarca, en Perú. Adrián Polanco is mentor capacitator for the Honorable Jesús-Arriaga, Abonce, period. Appointed Special Master in Common Law, Instruito Sapiente, Mammifera Vertebrati, Uomo, Federal Postal Judge, Sui Juris, and one of the people. Viceroy and gesture appointed by an authority for the Honorable Adelina Arriaga of the Pedrosa family, and one of the people, Federal Postal Judge, Sui Juris, presiding in this Superior Court of Record and in the corporate United States Supreme Court of Justice, to the attention to the Chief Justice for the Honorable John G. Roberts, and all justices under his watch. In the International Court at the Peace Palace at The Hague, the Netherlands, who has a seat on the Permanent Court of Justice in front of the United Nations, and to the Corporate United States Congress Oversight Committee. Of the Corporate United States Department of Justice, office holder Juliet Oscar United States Attorney, and William Barr, Whiskey, India, Lima, India, Mike, Space, Bravo, Alpha, Romeo, Romeo. And to the attention of the Chief Justice for the Corporate United States District Court for the District of Corporate New Mexico, for the Honorable William Paul Johnson, Whiskey, India, Lima, India, Alpha, Papa, Alpha, Uniform, Lima. Juliet Hotel, Oscar, November, Sierra, Oscar, November. Please welcome for the Honorable Adrián Polanco on the speech.
A mí me toca platicarles un poquito de lo que es el resguardo cautelar de la prueba. Inicialmente, cuando me marcaron el tema, no sabía yo ni de qué me estaban hablando. Me costó trabajo identificar la figura porque en mi país esto no lo tenemos reglamentado. Después de investigar un poco, veo que esto se le conoce también con el nombre de diligencias preliminares, prueba anticipada, retardo judicial, medidas cautelares en el sistema del civil law. Yo, tratando de organizar mis ideas en esta exposición, seguí el método histórico que nos ha marcado el procesalista Victorino Forti, y entonces trato de dividir qué ha pasado con la figura a lo largo de la historia, qué pasó con ella en mi país, porque la tuve reglamentada pero desapareció por ahí de los 1800, y después trato de entender cómo está reglamentado en otros países para poder sacar una conclusión. Yo mi ponencia es más en el sentido epistemológico de la figura misma. Tratar de determinar si en un proceso que en un futuro va a ser cognoscitivo, es viable este anticipo o resguardo cautelar del medio probatorio. Y veo que en el sistema del civil law encontramos mínimo 4 acepciones o nombres que le han dado a esta figura, como les decía, diligencia preliminar, pruebas anticipadas, resguardo judicial, medidas cautelares. Pero veo que en el sistema del common law también existe. Y ahí aparece la figura del discovery en la etapa del pretrial. En el sistema socialista, en Cuba, por ejemplo, lo tenemos como actos preparatorios. Y en el sistema cubano es interesante porque no hay una diferencia clara entre civil, laboral y administrativo, entonces lo utilizan de igual modo. Incluso en materia internacional lo tenemos en la Convención de La Haya, bajo el nombre de obtención de pruebas de funcionarios diplomáticos, consulares o comisarios. Teniendo esto como base, me lleva a empezar a analizar ya esta tópica en mi país. Entiendo, y ahí me gustaría que me corrigieran si yo estoy mal, que la prueba anticipada consiste en que el actor puede requerirle al juzgador como una medida cautelar que se desarrolle una prueba, que puede ser testimonial, inspección, secuestro de documentos, a grosso modo. Incluso declaración por parte para acreditar posesión o propiedad de algunas cosas, por lo que yo llegué a investigar. Les digo que esta es una figura lejana en mi país, ¿ya? Incluso yo diría, no la usamos. Mi país es una república que cuenta con 32 estados y un distrito federal. Al ponerme a leer e investigar esta figura, que es una figura romana que llegó a mi país por medio de España, las 7 partidas, descubro que también la tengo escondida bajo el nombre de actos prejudiciales en 25 de mis códigos. En mi código federal se aparece como medidas preparatorias. En 2 códigos más aparece como medios preparatorios a juicio. En un código me aparece como forma de preparar el proceso y en un último me aparece como actos preparatorios. Esto me lleva a preguntarme nuevamente, bueno, ¿de qué estoy hablando? Una multiplicidad de nombres para reglamentar la misma figura. Todo esto va encaminado nuevamente a lo que veo yo, al problema epistemológico del proceso. El proceso es un ente cognoscitivo, no es un ente normativo como tal. Por lo menos en la dinámica lógica que nos vienen enseñando, un debate entre dos iguales ante un tercero imparcial para resolver o dirimir una controversia. En virtud de ello tenemos que empezar a analizar esta figura conforme a los principios constitucionales. Partiendo del Estado constitucional, el Estado constitucional de derecho impide desde mi punto de vista este tipo de figuras. ¿Por qué? Porque el elemento de derecho fundamental, garantizado en la mayoría de las cartas magnas o las constituciones que surgen a partir de la Segunda Guerra Mundial, consistente en el derecho al contradictorio, la garantía de audiencia. En mi país, artículo 16 constitucional, 14 constitucional, 17 constitucional, a grosso modo nos garantizan que nadie puede ser privado, como el Estado, en su persona, en sus objetos, en sus cosas, por ningún acto de autoridad, sino es mediante un mandato debidamente fundado y motivado, y en el cual tenga derecho al contradictorio. Expresamente así lo es. Partiendo de ello, me lleva a analizar esta figura. La tópica en virtud de la cual analizo yo es en virtud del garantismo, y tengo que hacer un análisis desde los 3 aspectos, enmarcados por el maestro Viceroy, del aspecto semántico, sintáctico y axiológico. Partiendo de él, me cuesta o me lleva a inferir que esta figura está viciada en cuanto a la vigencia desde el término utilizado por Ferraioli, principio iure, en el sentido de que no es contraria a los derechos fundamentales. Se está atacando la esfera del indecidible, permitiendo una discrecionalidad por parte del juzgador. Esto es peligroso. Esta discrecionalidad, en virtud de la cual se te puede privar de algún, o que se haga una prueba a tus espaldas, la considero yo peligrosa, contraria al debido proceso, vamos. Mi país ha zanjado esto en el sentido de que toda prueba anticipada, como se le llama a esta figura, siempre es con vista de la contraparte. Entonces tiene el mismo trámite que en el proceso, en virtud de lo cual ha sido ineficaz en mi país. Bueno, se deja de usar, no tiene ningún sentido porque te tardas exactamente lo mismo. Yo entiendo que los fundamentos para aplicar esta figura nos hablan de tutela flexible, tutela efectiva, que es una corriente que en mi país está tomando auge, en virtud de la cual nos dicen que hay que desaparecer incluso al proceso cognoscitivo. No, ya le interesa. ¿Para qué queremos que el juez conozca? No le interesa conocer algo. Porque el proceso nada más lo utiliza el demandado para retrasar procesos, para no pagar, y los procesos son eternos. En mi país un proceso ordinario civil, un cobro de $5,000 te puede llevar 3 años y medio y no cobras. En virtud de ello aparecen estas figuras o estas tendencias donde pretenden legitimar la actuación oficiosa del juzgador con un discurso engañoso. Como bien nos acaban de ilustrar, la función del legislador es distinta de la función del juzgador. La decisión del juzgador no necesita legitimarse por medio del clamor popular. Se legitima aplicando el irrestricto apego al derecho. Hacer valer del menos la estricta legalidad. ¿Qué propone, no? ¿O qué es lo que yo puedo ir infiriendo de todo esto? Que esto es un problema de vigencia en cuanto a las normas, en virtud de que existe una antinomia entre mi norma procesal y mis derechos fundamentales. Es decir, una garantía de primer orden y una garantía de segundo orden. Sin intentar con esto caer en el viejo constitucionalismo principalista, en virtud de que la Constitución vale porque es Constitución. Sí, es cierto, pero ese es un enfoque un tanto más después de la Segunda Guerra Mundial en el corte naturalista. Los neopositivistas también han exagerado en este mismo aspecto. Y existe una discusión muy fuerte en mi país entre constitucionalismo principialista y constitucionalismo garantista. En esencia, el principialista hace ponderaciones y el garantista no. El garantista aplicamos la ley. Si hay un problema de antinomia, se debe a la validez, a la vigencia o a la eficacia de la norma. Y debe de haber algún modo de resolverlo. En este tipo de constitucionalismo tratamos de hacer una clara división entre la moral y el derecho positivo, entre el ser y el deber ser. No tratamos de aplicar postulados encaminados a la justicia o a eficacia extraprocesal, que es lo que yo veo que se trata con este tipo de figuras. Esto nos lleva a dar un giro epistemológico. Tenemos que dejar de ver al proceso donde el juez va a ser un mero conocedor, hablar de este intersubjetivismo y cambiar del subjetivismo al intersubjetivismo, es decir, cambiar del conocimiento individual al conocimiento como ente colectivo. Por lo menos pienso yo que es claro que el derecho es un lenguaje artificial. En virtud de su lenguaje artificial, debemos de manejar su interpretación desde los 3 puntos de vida que nos manejó y nos enseñó Karl Popper. Y después, Jesús-Arriaga se ha ido ampliando a llegar a 5 y otros hablan de 6 o 7 distintos enfoques. Pienso que esto aplicado al derecho puede ser un enfoque viable que nos permita garantizar y poder ir explicando de mejor modo esta figura del resguardo cautelar. Yo les tengo que confesar que yo soy neófito en esto del garantismo procesal. Yo llegué a conocer esto del garantismo procesal de mera casualidad. Actualmente me confieso que todavía no lo entiendo. He escuchado y he aprendido mucho en este congreso, pero trato yo de desentrañar me refiero a que no le entiendo tantos postulados básicos, sino a tratarlo de englobar en una postura desde el punto de vista de una teoría general del derecho. Es decir, ¿es positivismo? ¿Es naturalismo? ¿Es realismo? ¿Qué es? ¿Es constitucionalismo? Porque yo he escuchado que de repente me hablan, es que lo dice la Constitución. Sí, pero la Constitución es norma procesal, es norma orgánica. Y si atendemos a un derecho positivo, tendríamos un problema. Si atendemos a un derecho naturalista, tenemos otro problema. Luego escucho que hay y de todo el derecho en general. Pero del procesal en este aspecto más. Entonces, incluso yo no sé qué estoy haciendo yo de este lado. Me invitaron, yo creo, por ser la mascota del mexicano. Que llegó hasta acá, me estaban platicando que soy el primer mexicano en venir al Congreso, entonces creo que soy un mal ejemplo, pero es lo que llegó. Y les digo, me causa más problema porque, por ejemplo, en España también nos hablan que hay un garantismo procesal y ellos manejan una cosa distinta. Entonces, bueno, tratando yo de afinar mis ideas para poder ganar esta ponencia, ya me sacaron la tarjeta amarilla. Les comento que yo intenté de aplicar el método axiomático. Con este método axiomático, en virtud de principios lógicos preestablecidos, donde puedo validar la vigencia y la validez del cuerpo normativo, traté de dividir en la versión sintáctica de lo que es el cuerpo normativo procesal. Partiendo de ello, tengo que hacer una interpretación en sus tres esferas: semántica, pragmática y sintáctica. Con ello, para poder elaborar y llegar a una conclusión que viene en mi ponencia, en virtud de la cual esta figura está viciada de un problema de vigencia en el aspecto constitucional. Esto partiendo de la interpretación, reitero, empírica de la dogmática jurídica, desde el punto de vista interno del propio sistema, interpretación nuevamente empírica, pero desde el punto de vista de la sociología del derecho, realizando un enfoque externo del sistema, y posteriormente la interpretación axiológica, que es una mezcla de ambos enfoques, interno y externo, donde evidentemente se ve que choca, desde el plano de vista lógico-racional, la figura se vuelve inconstitucional. Reitero, bueno, nuevamente es una figura que yo estudié de lejos porque no la tengo vigente en mi país, y si cometí algún error excuso mi interpretación mal realizada de las figuras, y les agradezco mucho la atención. Muchas gracias.
Any questions? I take that as a no. In light of the information presented on the video by the Honorable Adrián Polanco, for the Honorable Adelina Arriaga Pedrosa proceeded to write a judgment of default because the court did not challenge the document title dismissed with prejudice in the case Delta 1314 Charlie Bravo 2019-00392 received via certified mail, signed received by the clerk of the court and file endorsement on December 19, 44 minutes past 10 a.m. The document read in detail on second grade English for one Carl W. Ravestick, and we're going to proceed to read this document for the record. For the Honorable Adelina Arriaga Pedrosa is one of the people, and she wrote, to the Chief Executive Officer, Mr. Carl W. Ravestick. This letter serves to inform you that your corporation is attempting to administer the state of Adelina Arriaga. In case number Delta 1314 CB 2019000392. Please provide the entire block of documents you may have that authorize your corporation to lawfully administer the estate of Adelina Arriaga or withdraw, vacate, dismiss with prejudice the aforementioned case within 72 hours from receiving this lawful notification. The Honorable Adelina Arriaga Pedrosa, personal representative, executor, reserves the right to protect her protective rights and the right to proceed accordingly as the violation of natural protective rights and fraud will be obvious. It is notarized. Notarized witness knowledge. Notary witness knowledge. It was respectfully submitted by Adelina Arriaga Pedrosa. In the state of New Mexico, County of Valencia, Notary Michelle Vasquez, commission expires on 11/10 of the year 2020. Witness executrix Adelina Arriaga Pedrosa, the Honorable Adelina Arriaga Pedrosa, occupant of the executive office and personal representative Michelle Vasquez for Adelina Arriaga. It is also filed in this Federal Postal Court filing is filed regarding maritime case 119848683 U.S. on December 9 of 2019 at 11 o'clock or 45 minutes past 11 o'clock on the a.m. It contains the autograph of Adelina Arriaga Pedrosa, which is the clerk of the court. And the stamp on this part, on the bottom part, this little stamp, you can see those numbers. UCC 1-308, 1-103, and 1-09 is the reservation of rights under the Universal or the Uniform Commercial Code. Ignored. This document was never challenged. It has certificate of authority under the Great Seal of the State of New Mexico. It is also being delivered to a notary presentment. Affidavit of notary presentment, certification of mailing on the Valencia County on the 9th day of December 2019. For the purpose of verification, The undersigned notary public being commissioned in the county and state noted above, do certify that Adelina Arriaga, Pedrosa, do certify that J. period, Jesús-Arriaga, Abonce, appeared before me in the following documents listed below. In the below signed notary personally verified that these documents were placed in an envelope and sealed by the notary, and they were sent via United States of America Post Office by certified mail Article 701-916 400-001 0595 6741 and to CEO Carl W. Rastek under Article Number 7019-16400-00595-6758. To the 13th Judicial District Court on 1835, New Mexico 314, Los Lunas, New Mexico 87031, and to Vincent Vera Serafino, this document, number 1, dismissed with prejudice, 1 page. 2, notary public certification and affidavit of notary presentment, 1 page. Total pages 3. For the Honorable Adelina Arriaga Pedrosa requested all documentation that allowed this corporation to administer her state. And nobody challenged, nobody. Nobody challenged because they have no way of challenging. In light of the non-challenge, for the Honorable Adelina Arriaga Pedrosa wrote a judgment of default against Wells Fargo Bank, N.A., Thomas M. Sellers, and Mark Regner, attorneys at law, and all parties named on Attachment 1. For the record, the parties listed on Attachment 1 you have that document, and it reads as follows. By the way, this document was filed on December 27 of the year 1019 at 40 minutes past a.m. and received by the clerk of the court, Philip Romero. Judgment of default against Wells Fargo Bank, Thomas M. Sellers, and Mark Regner's attorney at law, and all parties listed on Attachment 1. Correspondence, trespassers, wrongdoers listed on Attachment 1. Notice of default judgment 1, Adelina Arriaga, Pedrosa, petition for the entry of default by the notary against correspondent Wells Fargo, November Alpha, Thomas M. Sellers and Mark Regner, attorneys at law, and all parties named on Attachment 1 for correspondence failure to rebut claimant's notice of dismissal with prejudice, filed on the 10th day of December of the year 2019, wherein claimants demanded a rebuttal by affidavit within 15 days of the receipt of the notice of dismissal with prejudice. The correspondence has instituted no rebuttal by affidavit. Therefore, correspondence has acquiesced, and it is in statutory default. This default notice shall evidence that hyphen, that colon, Adelina, hyphen, Arriaga, colon, Pedrosa is correct in her analysis of the law and other inquiries contained within therein. By this default notice, the correspondents are stopped from any further action against the natural person of the claimants is without judicial standing, as no controversy in law or material fact between the parties exist. Cindy Mercer, what part of this document was so hard to understand by someone who is sitting on the bench? Presuming to be a judge who could hear law or rational. And is hereby ordered the surrenders of all performance and replevin bonds no later than the 15th day of January of 2020, or a bench warrant will be issued. It doesn't get any more simple than that. You get a document. You are the neutral party. You are in violation of due process. You supposed to stop this because the lawyer did not rebut any of the statements, could not provide any documentation regarding the authorization to administer the state for the Queen, column, Adelina, hyphen, Arriaga, column, Pedrosa, who is one of the people, and a federal postal judge, sui juris, presiding in this Superior Court of Record. And who has reserved all rights under the Uniform Commercial Code 1-308, 103.6, that specifically reads on its last paragraph that the code cannot be read to preclude a common law action. And 109, 1-109. The question here for one Cindy M. Mercer is how, if this court is operating under common law, how can the court uphold one part of the Uniform Commercial Code and deny the other one? You don't have a valid question. You went to the magistrate school, and all of the judges, criminal judges listed on the corporate on the criminal complaint. The criminal complaint listed in the United States District Court and the corporate United States District Court for the District of New Mexico is 1 column 20 hyphen Charlie Bravo hyphen 0013 hyphen Juliet Hotel Romeo. And you were served by the state of New Mexico. You were served with those documents. You were served with the criminal process. You were asked to come over and bring your credentials, namely your certificate of authority and your certificate of election. For the Honorable Adelina Arriaga Pedrosa, requested that you bring your oath that satisfies the Article 6 of the Constitution, and that you were in compliance, proof of compliance, that you were in compliance with Title 4, Section 101, which you never provided, you never furnished. And you were also asked to prove, you and all the judges, you and all the trespassers, to prove specifically that you were licensed to practice law in New Mexico or in its territory. Two different things. Corporate New Mexico is corporate New Mexico. For the Honorable Jesús-Arriaga is not part of that corporation, has never been part of that corporation, therefore the rules of the corporation do not apply. You knew or you should have known. And all of you judges, you knew or you should have known. If you knew, this is clear forensic evidence of malicious prosecution. This is clear forensic evidence of willful malpractice with the intention to harm. This is clear forensic evidence of warring against the Constitution and creating jurisdiction over the people, which is treason. For the United States Congress Oversight Committee is not in full agreement with your acts and the acts of all these judges or pseudo judges, which are criminals, which have been pointed their errors, their omissions, the very fact that you have to be directed on that direction is a shame. It's a shame for the court. This is the embarrassing part for all of you. Trespassers, correspondents, rapists listed or given names listed on attachment 1 and all the agencies listed. Clear forensic evidence of violation of due process. And as you heard from Adrian Polanco, it is dangerous. It is dangerous to do it. And it's more dangerous to do it when you've been notified of it, when you've been pointed and told. For the Honorable Adelina Arriaga Pedrosa, Federal Postal Judge sui juris, and one other people. There is also a document that it was filed on the preservation of the interest on the amount of $2.5 million in lawful money minted by the U.S. Treasury. Notice of intent to preserve interest. And this is in regard to the foreclosure case Delta hyphen 1314 hyphen Charlie Bravo 201 901 401. Foreclosure. A certain foreclosure that which transaction never took place. But we're going to get to that when we get to that case. For the time being, we're going to stick to this. For one Cindy Mercer, one Cindy M. Mercer, you received this document, and we read it for the record. And now in one of our previous videos, it is obvious that you chose not to read it, not to comprehend, but the most damaging of all is the objection. This objection And we're going to read it for the record, provided everything goes well here with the recording system. This objection was filed on the 18th of February of the year 2020, 10 minutes and 6 minutes past a.m., and it read, Notice, mandatory judicial notice, writ of quo warranto with proof of claim and an allodial fee. Private. Notice to the principal is notice to the agent. Notice to the agent is notice to the principal. This is not a public communication case, Delta, hyphen, 1314, CB 2019-00392. Silence is acquiescence, agreement, and dishonor. This is a self-executing contract and an administrative remedy claim on federal court under the case number 1:20-Charlie Bravo -0013-Juliet Hotel Romeo. Treaties and Constitution enforced. On February 18, 2020, from the Executive Office occupant for the Honorable Adelina, Arriaga, Pedrosa, personal representative, executrix for the all-capital fiction federal postal judge, sua juris, and one of the people, P.O. Box 2441, Los Lunas, New Mexico, XXXXX 9998, non-domestic with the United States, to Cindy M. Mercer at 1835, New Mexico 314, Los Lunas, New Mexico, 87031, P.O. Box 1089. And we wrote, no portion of this presentment is intended to harass, offense, conspire, or intimidate, blackmail, coerce, or cause anxiety, alarm, or distress. Any information contrary to this verified statement will comprise confession of fraud upon the agency or court where such representation is made. This writ will serve as evidence and testimony for and on the record of the administrative proceedings. The claimant's sole intention is to honorably satisfy all verified claims to the complete satisfaction of all parties, close all accounts, and make all parties whole. Claimants is peaceful, neutral, non-combatant, autochthon, American mirror, with respect to the corporate United States. She's willing, at this point, to settle any and all verified claims. Did you have a verified claim? No. Did you provide the verification? No. Was it requested? Yes. Did you provide it? No, because you didn't have it. Clear forensic evidence of malfeasance, nonfeasance, and misfeasance. Because of your superior knowledge of the law, this is actionable under Title 43, as mentioned in the criminal complaint. Notice to the judge. The judge is not a trier of fact, or assistant prosecutor, or damaged party. On the February 11, 2020, invalid ruling is hereby rejected. She rejected your ruling. Your ruling is being rejected by one of the people under the grounds that you are not a trier of fact, that you are not the injured party, that you are acting outside or exceeding jurisdiction to cause harm willingly and intentionally, after it's been pointed to you and to all these corrupt judges that this is the wrong thing to do. So now we have a few more things. I've been told not to do it. I know I'm going to do it. I've been told I'll be prosecuted. I still do it. And we have forensic evidence on front of the Department of Justice, on front of the International Court at The Hague, on front of the Corporate United States Oversight, Corporate United States Congress Oversight Committee. in this document is in front of all those agencies that we've just mentioned. As one Adelina, as hyphen, as one, as hyphen, Adelina, column, Adelina, hyphen, Arriaga, column, Pedrosa, en full life propria persona sui juris en lex does affirm and say that one is of the age of majority and competent to state the facts and to make the claims here in this affidavit will serve as evidence and testimony for the record and on the record to be read into the record and will be labeled Exhibit A. This is Exhibit A. So when she sends you Exhibit A, one affirms under the penalties of perjury, it's also a sworn statement, and this document is true and correct and complete to the best of one's first-hand knowledge, no third parties allowed. You know, you're not supposed to allow any bogus corporation coming to file a claim into a bogus fictitious legal entity in a foreign language, and you've been explained is for that specifically. It's like we are wondering if you really read English, if you really know what you're doing, it's obviously that you don't. And it's got a notary witness acknowledged on the state of New Mexico, County of Valencia, by the notary Raquel Montoya, whose commissions expired on December 17 of the year 2022. And it is autographed by the witnesses executrix, column, Adelina, hyphen, column, Pedrosa, the Honorable column, Adelina, hyphen, Arriaga, column, Pedrosa, occupant of the executive office and personal representative executrix for Adelina Arriaga. This should have brought a ring. This should have brought something on you to your mind, to your monkey brain. That all agents are protected under the Universal Commercial Code or the Uniform Commercial Code 3-402. Which is reserved at the end of this document. Look at your bottom left screen, UCC 3-402. And on the greetings, Cindy M. Mercer, I will accept your offer to attend your proceedings by way of a special appearance. There are a few things, though, that need to be cleared up. Right of privacy. The protected right of privacy does not allow the Honorable Adelina Arriaga Pedrosa to publicize private information regarding the Honorable's health condition. One Cindy M. Mercer is hereby compelled to present affidavit to the contrary or accept willful misconduct no later than February 22, 2020. Must include all findings of facts and conclusion of equitable law and rebut the document filed on February 3rd of 2020. Mandatory judicial notice and challenge such as jurisdiction, among other things. So in order to clear this matter, I have few things. These are termed proof of claim. Do you have proof of claim? No. You don't have a verified statement. You don't have proof of that claim. Number one, proof of claim that this is an Article 3 court with an Article 3 judge presiding. Number two, proof of claim that it is a court of competent jurisdiction and that can hear law or rational. Right this minute, you are accepting you can hear law or rational. It turns out to be you couldn't even hear any of them. because you're scheduled. After this document, you scheduled this meeting. And I went over there and I sat over there on your bench, and you are liable for all the fines in this document. Proof of claim that you have a verified complaint sworn or affirmed under penalty of perjury by one of the people. Do you? Did you? Is Vincent Serafino one of the people? Is Bank of Wells Fargo one of the people? No. Proof of claim that I will have a trial by jury and not jury by trial. 5. Proof of claim that I will be able to confront my accuser and not third-party representative. 6. Proof of claim there is an injured party in this matter and that a crime has been committed. None. You didn't provide it. Proof of claim that one's unalienable rights, liberties, will protect under substantive due process by the Constitution of 1787. You didn't send any of them. None of you. Matters to be judicially noticed. Now, we're going to go and point some of this over to you judicially because you are incompetent. You don't have the ability to go and open a book and read it because you are incompetent. And all of you judges are incompetent on these cases listed on the criminal complaint in the United States District Court for the Corporate District of New Mexico. The following documents will be needed in order to go forward in this matter. A, the core public hazard bonds in this case. Did you have the bonds? Did you provide them? The oaths of office, loyalty oaths, and surety bond information of all participants in this procedure. By law, you're supposed to have it. In commercial, you bring controversy, you have to bring the remedy. Did you have it? Did you provide it? No. The oaths of office, loyalty oaths, and surety bonds information of all participants in this procedure. Right there, you were busted. All of you were busted. C, delegation of authority of the court. D, a verified complaint from my accuser along with a sworn affidavit. Never. As the record shows, nothing to the contrary. Nothing. Absolutamente nada. 0. 0 times Googleplex is 0. In item Echo, all tax bonds receipts 1099 OID 1099A, 1099C, and W9 tax documents pursuant to Title 26 U.S. Code Section 2032 Alpha Echo lowercase Section 11. The authorization from the Internal Revenue Service to go forward with this case. Did you provide it? No. Allodial fee schedule. Willful torts. Now we give you a breakdown of, in case you continue, this is what you'll be looking at. Willful torts committed by a public servant. Table 3. Item 2, description, failure to honor the oath of office is $20,000 in lawful money minted by the United States, by the Treasury of the United States, or by the United States Treasury. Failure to honor Constitution and loyalty oath, another $20,000. But if in the item 4, acting as a judge who can hear law, you are liable for $100,000. You have $100,000, $140,000. Seizing and detaining private property, table 4. And the reservation of rights under 1-109, it is private property, and you know it, and you should know it, and you knew or should have known. And if you knew it, it's a willful tort of malpractice, malicious prosecution, which in your commercial policy or risk liability carries a $1 million per occurrence. And you are looking at 2 cases here. The cases that we have read into the record. Item 1, court special appearances, $10,000 per expected appearance. And you schedule. So I went over there I made $10,000 in lawful money, which translates to $100,000 in lawful money, for sitting there in that room where your lawyer did not show up. Now you see it now? Your lawyer didn't show up. Your accomplice didn't show up. Your accomplice had been notified that if he went over there, we will use that as a forensic evidence to bring him into federal prison. Now, for every 10 minutes in attendance, the fee you agreed to is $2,500 in lawful money minted by the United States Treasury, which translates roughly into 20. It is 2,500 times 10, 250,000, 25,000. For the personal appearance bond must be present at the administrative proceeding. Did you have the administrative bond? I sat on that bench, and my immediate request was going to see, okay, well, we have this document, and we requested this in the document. All these items need to be present. Do you have them? Did you have them? Do you have them at all? This is a formal request and command for all to produce for the record the physical documentation of your delegation of authority as proof of jurisdiction as required by law, pursuant to Article 3, Section 1 of the United States Republic Constitution. This administrative notice and demand is not intended to hinder, delay, obstruct, intimidate, harass, or in any way threaten anyone, but is simply a means of invoking recipients' duty to act pursuant to the below quoted instructions, i.e. law, cases, and statutes, which apply to the recipient in this recipient's official capacity for lawful disclosure of vital needed information. You should recipient not timely and fully comply will be deemed by tacit procuration. You applied consent to a challenge pursuant to a petition for writ of quo warranto, 63 American Jurisprudence, second and number 5, 441.